Good morning, everyone. I, Vijay Lakshmi HM, Assistant Professor, Department of Electronics and Communication Engineering, St. Joseph Engineering College, welcome you all to the second day of Techno Legal Summit on air, jointly hosted by St. Joseph Engineering College, Mangaluru, and SDM Law College, Mangaluru. Today's webinar is on overview of patent and how to conduct patent search, which is very relevant topic of the hour. Now I take the privilege to introduce the speaker to the audience. Dr. Purushothama Chippar is currently working as a professor in the Department of Mechanical Engineering at St. Joseph Engineering College, Mangaluru. Before joining SJC, he worked for Honeywell Technological Solutions Lab, Bengaluru, as a senior technologies analyst for about 3 years. He is well experienced in identifying technology gaps, formulating technology, IP strategies, and patentability searches. He pursued his master's and PhD from Inha University, South Korea, and Bachelor of Engineering from Malnad College of Engineering, Hassan. Till date, he has 30 research publications, which includes 18 peer-reviewed articles in international journal. His invention titled Aircraft Prognostic System and Methods of Determining Adaptive Time Between Overhaul on the Line Replaceable Units is awarded in US patent. Currently, he is working on the project funded by Vision Group of Science and Technology, Government of Karnataka. He has completed the project from the Institute of Plasma Research under the Authority of Department of Atomic Energy, Gandhinagar, Gujarat. He is a certified patent information specialist from WOL, Dutch Patent Information User Group. Hearty welcome to you, sir. Now, I would like to request Dr. Purushothama Chippar to take over the session. Over to you, sir.
Yeah. Thank you, madam, for the introduction. So, am I audible?
Yes, sir. Yes, sir.
Okay, fine. So let me start start this session with a story, which is related to patent. So this is something patent troll in a modern world. This is a controversial word used, patent troll. That means one company sues another company for the infringement of any idea which falls beyond their patent scope. For example, company X has some idea and they got the protection. They are suing company Y for infringement, but it's not at all overlapping. This is called patent troll. Okay. So, as you know, Wright brothers first invented the first flying machine. Okay, on December 17, 1903, they invented the flight, and 1906 they got a patent for one mechanism, because when they built the aircraft, they had one problem, that is instability. In order to control instability, they developed one mechanism called wing warping mechanism, and they got a patent on 1906. So at that time, many aviators who built their own aircrafts, and Wright brothers, they thought they have the complete authority on the lifting mechanism of aircraft phenomenon. So they started suing others, competitors, and even competitors got angry, and there was a legal fight. Okay, legal fight started. This is considered as the first patent war. Okay, so there, in some countries, it was in favor of Wright brothers, and some countries were not. And during this process, one of the competitor called Glenn Curtis, he also developed an aircraft. Actually, basically, he is a motorcycle mechanic. So he developed one mechanism, and it's called for one solution. So one problem, there are multiple solutions. So his solution was using the movable flaps. But Wright brothers thought that he is infringing their patent claims. So he started, they started suing Glenn Curtis also. So legal fight started, And it was very lengthy legal flight. It started from 1909 to 1917. Then what happened, in between, right, his elder brother he died due to some illness. And when they wanted to sell their company in 1950, their company was right. When younger brother wanted to sell their company, they were in dangerous position because during this legal, they almost neglected the research and development. And by the time they wanted to sell their their aircraft, it was obsolete. There was no, R&D, and by that time, many aviators they built, aircrafts better than theirs. And that time, US entered into the World War, and they didn't have any aircraft that time. So what they did, they said, okay, please stop fighting. Let's have a patent pool. Patent pool means, all the aviators, they come together and they share the information, and desperately we need aircrafts. So that's what, the patent pool concept also came, and all the aviators came together, then they started building the aircraft needed for the US Army. Okay. So here is my presentation contents. First, I will discuss about the intellectual properties, different types of intellectual properties. Then we will discuss in depth patents, patentability criteria, disclosure strategy. If you have any concept, if you have any idea, what are the measures you should take before you disclose to a company or individual, angel investors, or anybody. Okay. Then we'll discuss about what is prior art, importance of prior art, and how to search for prior arts, examples of prior art search. Then finally, for the benefit of audience, I will just touch upon this patent prosecution in India for the Indian applicant perspective. Okay, first, what is intellectual property? Intellectual property, IP, refers to creations of the mind, such as inventions, artistic works, designs, symbols, name, or images used in commerce. IP is protected in law by, for example, patents, copyright, trademarks, which enable people to earn recognition. Because if I'm an inventor, I spend a lot of money, effort, time to invent something. So I need some recognition and also financial benefit from what they invent or create, what I invent or create. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish together. This is the definition for intellectual property. If you ask me when this concept started, it goes back to French Industrial Revolution. That time it's a French, that the government then they started giving protection for the ideas for the companies, industries. Okay. Now, what are the different types of intellectual property? I am sure that some of you know them, right? Know the some of the intellectual properties. First one is copyright. Copyright is a legal term used to describe the rights that creators have over their artistic works. Works covered by the Copyright Act, music, paintings, sculpture, films, your business catalogs, any map you create, technical drawings, all this comes under copyright. And one more important point is softwares. So that I will discuss later. Okay. Because copyright, as you know, it comes under patents also when it's applied to some machines that we, softwares that we will discuss in detail later. Okay. And then patents. Patent is an exclusive right granted for an invention. Generally speaking, provides the patent owner with the right to decide how or whether the invention can be used by the others. In exchange for this right, a patent owner makes technical information about the invention publicly available in the published patent document. But it's not so in copyright. In copyright, you're not disclosing anything to the public. But in patent, you have to disclose your invention, everything to the public. Coming to the third one, trademark. A trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. It goes back to olden days, when ancient times, when artisans, they used to put their signs or some signature or some marks on their products. Next one, industrial designs. Best example, if you can take Coca-Cola bottle, right? It has a unique shape. So industrial designs constitutes the ornamental or aesthetic aspect of an article. It can be three-dimensional, like in a Coca-Cola bottle, or it can be some surface, shape, or it can be two-dimensional, like a pattern, colors, lines, etc. And coming to the geographical indications, I'm sure that some of you are aware of the geographical indications. The best example is Udupi Mallige, Dharwad Peda, Chennapatna Toys and Dolls, Wayanad Robusta Coffee. There are many. So geographical indications, it gives you the origin. If, for example, if you say Udupi Mallige, means you can see it's originated from Udupi, and it is unique characteristic compared to Mysore Mallige. So by looking at that name, you can identify from the origin, and you can guess the characteristic of that product. Coming to the trade secrets. Trade secrets are IP rights on confidential information which may be sold or licensed. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of the trade secret protection. So coming to the patent. Patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers new technical solutions to a problem. To get a patent, technical information you need to disclose to the public in patent application. Patent protection means that invention cannot be commercially made, used, distributed, imported, or sold by others without patent owner's consent. And one more thing, it's a territorial rights. For example, if I develop some recipe or some composition for some masala, okay, Indian masala. Indian masala, if you come up with some new way of doing or producing masala, you may be interested to get the protection in India or some South Asian countries. You may not be interested to get the right in the US, right? So then I will apply only in countries where I'm interested. That's why it is a territorial right. Okay, then later I will come to the international application also through PCT. Okay. And this patent is granted for a limited period. Otherwise, what happens? Government will be giving monopolistic. That company who got the patent can produce forever that product, and nobody else can practice that. So it should not happen like that. So government is giving 20 years life for any patent. For utility patents, for plant variety, again 20 years, and for design, it's 14 years. So here you can see the life of a patent. It starts with the concept phase. You have some idea, you go for patent filing. Then once the patent is granted, in case if the patent is granted, you go for commercialization. Then, as I told you, 20 years lifetime, you need to pay the fees that we call patent maintenance. Then at the end of the 20 years, it comes to the end. Okay. And 20 years from where 20 years starts? From the day of filing. Coming to the important parts, that some issues, for example, biotech and genes, computer programs, and nanotechnology. In some countries, you can get the patent for these three things, but most of the countries, they don't issue patent for these three things. Now coming to the biotech genes, who owns your genes? Do you own them if they are inside your body? But someone else can own them if they have been removed. Question is, are isolated human genes unpatentable products of nature? You know, this issue came in 9 Justice of America in 2003. And they just decision made. It's available in WIPO magazine. Those who are interested can visit World Intellectual Property Organization magazine. You can visit that. The question is whether isolated human genes are patentable or not. Okay. Second one is computer programs. As you know, computer programs, once it is created, means it is possible to reproduce the software easily at very low cost and unlimited quantities. Although copyright protection for softwares does not protect the concept behind the software, which often is an important part of the commercial value. Since such concepts frequently fulfill technical functions, such as controlling machine or processing data, a patent system, then you can apply for the patent system. Means if your computer program is used for controlling a machine or processing a machine, then with that you can apply for a patent. In recent years, a similar issue has arisen, namely the question of the patentability of business secrets or business methods. So among the emerging technologies, nanotechnology raises particularly high expectations in a wide range of areas affecting our daily life. Nanotechnology is a science which operates at an extremely low, small scale, 1 nanometer to 100 nanometers. So now it's easy to see how manipulating a matter at an atomic level would potentially lead to enormous developments. And concerning the general conditions of patentability, the question may arise as to whether the reproduction of a known product or structure at an atomic scale would meet the requirements of novelty, or more importantly, inventive step. It's a question now. So there were many treaties. In 18th century, there was a Paris Convention, and then there was a Patent Cooperation Treaty. There were many treaties. The Paris Convention for the Protection of Industrial Property, signed in 1883 in France, was one of the first intellectual property treaties. It established a union for the protection of industrial property. And this convention is still in force. And the Patent Cooperation Treaty is an intellectual patent law treaty concluded in 1970. It provides a unified procedure for filing patent application to protect inventions in each of its contracting states. It allows you to make a single international patent application such that one application in one language paid for in one currency. Coming to the patentability criteria, if you have an idea and you want to go for patenting, so what are the basic criteria it has to meet? The first thing is novelty. Second, utility. Utility means it should have an industrial use. Third one is non-obviousness. First one, coming to the novelty, for your idea to be regarded as an invention, at least one significant part of its technology must be completely novel. That is, it should be new. There must be no evidence that this novel aspect of your idea has ever been described before or used for the same purpose before. And please note that not all the technology of an invention needs to be novel. The inventive element might be only small part, but the small part can make the big difference in terms of commercial value. And to be regarded as invention, the idea needs to include an inventive step also. You know what is the inventive step means? It's a your concept should not be obvious to the person who is expert in that technology. For him, it should be a non-obvious thing. That is a non-obviousness. And I told you utility, it should have an industrial use. Now, if I have an idea, how to make sure that it meets the patentability criteria? For that, and first thing is the novelty. then I should do the novelty search. People call it patentability search, novelty search, okay, or prior art search. That we will discuss in detail later. Now coming to the point that disclosure strategy and confidentiality. For example, if you have any idea, so what is our general tendency is to tell others, right, that I have some idea like that. But what are the dangerous things when we disclose to others, especially in the public disclosure? Professors, they conference and disclose their ideas in the seminar. Or students, they exhibit their project in some exhibitions. And to a certain extent, Google search. Yesterday, we had a sessions on artificial intelligence, but I'm not sure to what extent others can come to know what you are searching in Google. It is possible, right? But I'm not sure to what extent others will check that. But I doubt that it is possible. For example, if you have some unique idea, or you have some idea, you search in Google, others can, using some AI, they can track, right? So that is also possible. Okay. And third one is talking to companies or angel investors. In that case, you should have a NDA, non-disclosure agreement. Without non-disclosure agreement, we should not disclose our idea to anyone, especially companies who are expert in that domain. If you speak little also, they can easily capture or easily understand what are you talking and what is your invention. So we should be very careful when we disclose our idea to anyone. Okay, there comes the non-disclosure agreement. We should sign a non-disclosure agreement before we disclose our idea to anyone. Okay, what is prior art? Any evidence that your invention is already known or it need not be exist physically or commercially available. Someone somewhere sometime previously has described. That's enough for prior art to be prior art. A prehistoric cave painting can be prior art. Anything can be prior art. An existing product is the most obvious form of prior art. Okay, what happens the time? If we have idea, we just look around in shops, some places we look around and we don't see that kind of products. And we say that, okay, my idea is novel. And because I cannot see any product in the market. Okay, please note that many inventions never become products. Out of 10, only 1 will come to the market. Remaining 9 will be in the document, but they won't come to the market. But they can be the prior art. And one more thing, competing art. When we search for, when we do the novelty search, you will find some ideas similar to this. They are called competing art. Ideas that may not be at all like yours, but do the same job. It is important to study competing art for 2 reasons. Most inventions are solutions to a problem, and most problems have more than one solution. You need to examine other solutions, as some may offer more advantages than yours. If you try to exploit your idea commercially, alternative solutions may be strong competition. In order to argue successfully that your solution is better than alternatives, you need to know what are the alternatives. And now, what is the importance of prior art searching? So, why we do the prior art search? Just to know that our idea is novel and it has the inventive features. It avoids wasting of money and resources. If you see any big companies, they have a separate IP department, and the job of this IP department is to do the patent search. Okay, for example, an inventor has come up with idea, and this IP department will check whether this idea is novel, inventive, etc. Then they suggest to the management to go for patenting, because during the patenting procedure they invest a lot, and there are chances of infringement also. So we should be very careful. So that's why we need to do the prior art searching. and it helps to identify the closest prior arts, thus can define the scope of protection. For example, you have made about 20-25 claims, and if you see some overlap with other prior arts, then you can fine tune, or you can tune your claims, you can modify your claims like a due diligence exercise that can reduce the risk of rejection of the patent application. Prior searches may also be used to determine the value of a potential investment. For example, if you have any idea and you can come to know what is the commercial value in the market. And this art of searching, when you search for any prior art, you should search for both product and also patent search. Both to be confident that you have done a prior art search. So you need to do the both product search and patent search. Idea. And if you do not look for it, companies or investors definitely they will check. For example, you have an idea and you got the protection and you want to sell it to any company. Before they your patent or your idea, definitely they will do the patentability. They will do this search. We call it due diligence search. Absence of prior art at the time of your searches may not be the permanent absence. That means, for example, you got idea today, and you need 2 months time to develop that concept, and you do the patentability search today, and you don't find any prior art, and you keep on working on your idea for 2 months, and after 2 months you are going to file that idea for patent protection. But if you don't do prior art, so that's why you need to do the prior art search just before you go for patent. And in law, not even an official patent office examination is a conclusive proof of novelty. You do the prior art search and then you go for filing the patent. And in the patent office, they will do the patentability search again. Even their report is not considered as the proof of novelty. So when you do the search, do not simply scratch the surface. Do the in-depth search. So what are the heart of searching? What is the technique? Spend some time thinking of keywords or search which best describe your idea. I will explain you. I will take few examples and I will explain you how to do that search. In search engines, most obvious keywords may not be useful. For example, if you search mouse trap in Google, you will get 2.46 million hits. But if you say rodent trap, you will get 0.3 million hits. If you enter trapping mice, you will get about 19,000 hits. Okay, so I want to tell you something here. See, you disclose your concept or idea to the government or to the ultimately to the public because government insists that. If I'm an inventor, I want to patent a product, but I'm not interested to disclose to public. But government insists you to disclose. Close to the public, then you keywords such that you not get that those. I will show you use it. Find better keywords to use for more accurate searches. For example, in software field like virtual fit for software systems to replace trying on clothes in shops, and telemedicine for remote monitoring of, and don't use a mobile phone. Some patents you can see that it's used as handheld devices and operated devices. Yeah. And where to search? You need to search everywhere, like patents, books, trade or professional, advertising catalogs, government documents, illustrations, non-patent literatures. When you do a product search, you need to find out what is already on the market. This is similar to an idea. If it is similar to an idea, it's a prior art. If it's tackles the same problem, it is called as competing art. And for products, you can visit news sites, industry journals, trade shows. Sometime in the press, they may disclose that we are going to come up with this kind of product. They're working on that. And you should also do some shops. For example, if you are interested to build a toy, then you better to visit some toy shops. Talk to people. I'll explain you later. In my patent, I had a lengthy discussion with a person who worked in Indian Air Force for 27 years. I just told him that I have this idea. Can he tackle that problem? Since he had a lot of experience, he said, yes, definitely your idea can tackle this problem. That's why I've gone for that patent protection of that idea. And patent searching. For me, patent searching will be important than product searching, because many patents will not go to the market. As I told you, out of 10, some experts say that out of 10, only 1 will go to the market. Patent searching involves 2 skills: finding every patent document that is relevant to your invention and interpreting the significance of your patent search findings. It's very important. You find the prior art and then interpret, study those patents. And when you search, your mission is to find evidence that disproves the novelty of your invention. What happens most of the time, we are biased to our intention most of the time not to find similar articles or similar documents, but that should not be the case. Okay, if you don't find any prior art, that means you are looking in the wrong place. Definitely, I can say that. Okay? And keep records of everywhere you look and everything relevant. Make a document of that. What are the best strategies to uncover essential information? That includes, first thing, understand the claims or the novelty of your invention. Keyword search. You frame the keywords which best suits your invention. Then classification-based search. There are many classifications like international patent classification, cooperative patent class. There are many, IPC, CPC, US. I will explain that later. Then you do assignee and inventor search. Then patent citation analysis like backward search and forward searches. Then also look for non-patent literatures. So this process, patent searching process is like this. First, you understand the invention and you do a lot of patents. Okay. Then you do the keyword search, assignee search, classification search. Then reduce the number of relevant patents. That is shortlisted references. Then you take from some documents from the non-patent literature. Then once you get about 200, 250 documents, 200, 250 patent. Identify probably most critical step. If you use wrong keyword, don't expect good results. Okay, so it's worthwhile to spend some time on this. How to identify keywords? Try and crystallize the 2 or 3 main components that makes your invention unique. Then try and think of all the synonyms and similar concepts. As I told you, mobile device. It can be called as cell phone, mobile phone, communication device, etc. Okay, because different inventors use different terminologies. While searching, you might discover more synonyms and alternative words and incorporate them in your next search. So here is one example. For example, if you're interested in the computer mouse, and if you just search mouse, the other one also, it will come. Okay, and use all the synonyms and alternative words. Go from general to specific. Okay. And you can see one gear I have shown here, and in different documents they use different terminologies for the simple gear. And here you can see, as we all know, this is spring, right? But one inventor throughout the document, he called it as energy storing means. If you would have searched in spring, then you won't find a document of this document. Sometimes the applicant simply doesn't want this patent to be found. I told you, intentionally I'm not disclosing my idea to the government because government insists me to disclose. That's why I'm disclosing. Okay? And simply you can see a toy ball. How one inventor has mentioned in this document, patent document, spherical object with floppy filaments. Strange. Okay. And select the databases. Okay, there are many databases for patent search. Google patent, very commonly used, and then you have USPTO, WIPO, eSpaceNet. There are many commercial softwares also. But what the first thing we need to do when we are using any database? For example, I tell you, if you search in Google X, Y, for example, X is the family given name and Y is the family name. If you search X space Y, then you will get documents with either X, or Y, or documents with X and Y. Right? But I'm interested with the documents with X and Y, given name and family name. Then I have to use X and Boolean operator and Y. What I suggest, typically what I generally suggest, before you search in any database, search how to search. Because in Google, if you search, how to search, or search tips in Google, then you will see different Boolean operators, truncation operators, wildcards. There are many operators you will find. Use them for effective search. Okay. First database, Google Patents. A good place to start search. We call it dirty search. Okay. In Google, you don't have to be very specific because it has got some limitation also. So you can do some keyword search for basic understanding. In the Google Patents, it takes 2 to 3 months for published patent application to appear. Okay, originally it includes US patent and now some Chinese and Japanese patents are also available. It does not cover many countries. Okay, I will tell you how these databases are different based on the coverage. And next one is ESpaceNet, particularly for European patents. Includes prior art from most of the countries. Advanced and simple search options are available, and it claims about 19 million prior documents. And one more option is you have a machine translation. You have an option there. And then WIPO, World Intellectual Property Organization. This database is managed by WIPO, and it's very advanced and simple search options are there. About 49 million plus prior art documents are available. Then USPTO, US Patent Office manages this site, and it's mainly for US patents. There are many commercial patent databases also, like Thomson Innovation, Questel, there are many. And as I told you, before you search in any database, you need to understand what are the operators available in that database. Like, for example, for truncation, for example, difficult. In some document, it can be. If you search only difficult, then you won't find documents with difficulties. Then what you need to do? Difficult. After T, you need to put the truncation operator symbol. Like in USPTO, we use dollar symbol, and in Google Patents, we use star. There are many operators, like, for example, you don't want any document with the phone, then you can put a minus phone. Then you are looking only for the PDF documents in Google, then you can put colon PDF. Only PPT, you can put colon PPT, then only PDFs or PPTs will come. Okay. Initially, when you do the search, you will get a lot of documents, broad search. Then you understand the classification. I'll explain that in the next slides. You have to narrow down your search. At the end, you need to summarize and then discuss and then prioritize or rate the documents with the first rank for the documents which is very close to your invention. Okay, like that you can rate them. And when you submit your patent application, you have to submit some prior arts. Without prior art, you are not supposed to submit. You have to submit some prior arts. Okay, coming to the classification, as I told you in the beginning, you can do keyword search, classification search, inventor search, assignee search, right? So what is the classification? So we have two major classifications. Earlier we had 4 classifications, later ECLA, that ECLA, and US classification, the 2013 January, CPC, Cooperative Patent Classification. Then we have IPC, it started in 1970, and IPC has about 70,000 technical fields. Okay? And you know why we need the classification, right? So we need to categorize the technical fields. I'll show you the next slide how the classification is done. In IPC, there are about 70,000 technical fields, and CPC has about 250,000 plus technical fields. They borrowed about 120,000 from ECLA and 120,000 from USPC and the remaining from ECLA, and combined together, it has about 200,000 plus technical fields. See the difference here, CPC and IPC. See how the class. F, H, electricity, Y, others. Okay. But if you see in IPC, Y is not there. It is covered in other classes. The document, this is my US patent. See here you can see this is a patent number. Okay. US and then patent number. And the B2, this is called kind codes. It shows you what kind of patent it is. Okay. B2 means public granted patent. When you submit a patent application, it will be given A1. It will be given some number, and after publication, after 18 months, A1 will come. And then A2 will come, republication. Then if it is granted, then it B1, B2, like that it will. Okay, and expired documents, they will have some unique code for that. Okay, then here is the title and the applicant or assignee, inventors, applicant and assignee is here. Then inventors, and this is a number given whenever you submit the patent application to any patent office, it will give some number. Okay, this is the number, and filed date, and this is the A1 when it was submitted. Then you can see international classification, that is IPC. Okay, it comes under G. You can see what is G means. So it's a B, classification G05. Okay, G05. You can search what is related to physics, some monitoring or testing. Okay. Then here it's written 2006.01. That stands for, because IPC every year they update. Every year January they update the IPC. So that's why they have put 2006.01. Then you have the abstract, claims, many other things, drawings, etc. Okay. Now let's have a cup of coffee, virtual coffee. Okay. So I will show you one invention. Okay. I'm sure that it's not a new thing, but I'm considering it as one invention. Okay. So what is the difficulty we face when we drink coffee or tea in a paper cup or plastic cup? It's difficult to hold, right, when the drink is hot, and you can even burn your fingers. So we try to hold the cup, and sometimes not possible, and we ask shopkeeper one more cup, or sometimes 2-3 cups to hold the 1 cup of tea, right? So for example, now I have one solution. Okay, let's take a simple design such that I have a stirrer, and then that stirrer I can attach it to the rim of that cup so that I can hold the cup, and then I can dispose it. Okay. So what is the key concept here? The handles have to be attachable or detachable to the cup, specific to the rim or bottom. I should be able to fix to the rim and bottom, and can also be used to stir the drink. Okay. Now let me do that search in Google Patents, eSpaceNet, and WIPO. Before that, I need to do the keyword. I need to frame the keywords. What are the keywords I can have? Cup, some synonyms, handle, disposable, stir, or spoon, something like that. Coffee, tea, plastic, optional. Okay. Based on these terms, let's conduct some dirty search in Google Patents. See how I framed the search string. Cup or jar, and I have put star. There's a truncation operator, and then and is there. Then I have put the bracket. Let's see how to search for queer art for the above invention. Okay, let me copy this. Okay. Copy this string, search string. Then I'll paste in Google Patents. Let's see. See, I got about 58,000 hits. Okay. Then there are options. You can priority date. For example, if you are looking only patent documents 2010 onwards, then you can put the dates. If you want to look for patents from the specific inventor or assignee, you can check. And also you can only look for expired patents or patents in act. So these patents you can search here, status, looking at the status. Okay. So this is how we can do patent search in Google. You can play with this search strings.
Chippar, sir?
Yes.
Sir, sorry to interrupt. Actually, since you are sharing the PowerPoint, when you go to the other browser, it is not visible, sir.
Okay, what should I do, sir?
You have to stop sharing and you have to start sharing the screen itself, the entire screen.
Okay,
Not
okay.
a particular application.
Okay, okay. Is it visible, sir, now?
Yes.
Okay, okay. Here is, sorry for that. Hello?
Yes, sir.
Okay, fine. Okay, here is my search string. So I searched in Google Patents. These are the hits I got, about 58,000 hits. Okay, and here you have some options. search options available. So you can set the priority dates, filing date and publication date, languages you can set, okay, and litigation, what is status, okay, that also you can check, and then you can filter out some of the search hits. Okay, so let's do in eSpaceNet. I told you about the classification. I will come to the search after some time. Say I told you about classifications, right? For example, human necessities comes under A. You click here, see you can see there are subclasses. For example, A21, edible or something baking, okay, and A43 about footwear, A42 headwear, okay. So if you want to see in detail about this subclass, click on this and you can see some more information like this. And if you want to go back, you can go back here, and again you can see the and check the other classification. For example, B. So what are the things comes under B? Y. Okay, you can search for the things like this also. Okay, now let's do the search. I will go to the advanced search. I entered earlier, so no problem. So I have cup, handle, disposable, and I have used the operator and. Okay, so I should get the documents with cup, handle, and disposable in abstract. If you want to change the fields, you can change that. Here you can see abstract, description, title, etc. So I want to see these three things in abstract. See, I got about 1,900 documents. Okay, you can see documents are very similar to that. Disposable plastic drinking cup with the handling positions. Disposable cup with the handle. And if you want to do, some narrow search, you can filters. Is option, filter option is there. Then if you are specific to some countries, you can select the countries or languages, publication date, etc. Okay. Then I will just open this document. Let's see. So when you open this document, a Chinese document, I'll go to some US document. The US document. Okay. See, here you can see the IPC classification, right? B65, it comes under B. B65D. If you click on this, you will get some information. Why this patent document comes under this category. Okay. And similarly, you can do in WIPO. You can go to patent scope. That is the database from WIPO. Then you can go for search options. Okay, you can go to access the patent database. Then they have different operators for patent search, and you can do the patent search. See, like this. There are options for front page, full text. And similarly, you can check in the USPTO, US patent database also you can check. Okay. And then what are the non-patent literatures? So like journal publications, some video articles available in YouTube that can be a non-patent literature. And one thing I have to tell you, in industries, what happens, for example, an employee has come up with some idea and he submitted to IP department for patenting. And company thinks that this idea we may not work in future, but we don't want others to practice that. So what they do, they go for defensive publication. Defensive publication means You simply write that you prepare one article on that idea and nobody is going to review that. You prepare one article and throw it to the public domain. There are many like ip.com. You can see one ip.com. Okay, there you article. So it is in the public domain. It acts as a prior art, so that others cannot obtain, your competitor cannot obtain patent on that, and you are not interested to produce that, manufacture that product. So that's what, defensive publication is also very important, and you should look at the defensive publications also. And now one more novelty search we will see based on the virtual object overlay. I think you know that it's based on augmented reality. It's merging of your user's view and the computer image. Okay. So I have taken one document here. See, here is the scope of patent search. Here is the scope of the patent search. And as I told you, we have to make the keywords. And for virtual reality, there are many synonyms. You need to list down them. For location, again, you have the many synonyms. Please list down those synonyms. Then make the strings. Then you should know on which database you are going to check. I will show you the strings used. See here, strings. Object 6. Near 6 is what we call, for example, this item is beautiful. Okay, item and beautiful, in between there is one word, right? So I can put near 2. Okay, the number of words between the important expected words. Object and overlay, there can be 6 words in between. Okay, and this searched in Thomson Innovation, and you can see different strings. And finally, you need to list down the relevant patents, your invention. And finally, one patentability report is there, patentability search report. It is also called novelty search report. See how, if you go to any patent agent or attorney, they will prepare the document like this. Okay. Okay, fine. So, okay, we have come to the last slide. Stages of patent prosecution in India. Okay, for Indian applicants. So there are 2 options. So now you have some idea and it's not fully developed. Your idea is not completely developed. So what you can do, you can lock that idea using provisional application. You can log that idea using provisional application, and then after 12 months you need to submit the complete application with all the needed things like claims, abstract, everything should be there in the complete specification. And after 18 months it will be published. After 18 months it will be published. 18 months from the date of complete application, and your priority date will start from the date of provisional application. If your idea is fully developed and you are ready to submit the complete specification, you can directly go for complete application. Then you need to request for examination. Most of the time, what mistake we do, no, we don't submit this form unless you submit a request for examination. Patent office is not going to examine your patent document. You're not going to check your patent application. Okay. You need to submit request for examination, that is within 48 months from the date of filing. Then after that, patent office examines your application and they issue the examination report, FER, first examination report. Okay. Then within 6 months, and it can be extended to 3 months with some request, you need to submit the response to examination report. Okay. Then they check that and granted or not granted. There is a pre-grant opposition from the publication date to the date of grant. There can be pre-grant opposition. Then after if it's granted, then they publish the document. Then after granting, for 12 months, there can be post-grant opposition. Here you can see, if you want to patent office to examine your patent application early, then you can submit a separate form for early examination. For that, you need to pay some extra fees. And at the end, you have the patent certificate. So where to file? So in India, we have 4 branches, 4 offices. And for us, Karnataka, it is Chennai office. Nowadays, it's most of the time it is online application. So by default, when you apply your location, that Chennai office thing will come. Okay. So these are the 4 offices for patent filing. I think I have come to the end of my presentation. Hello.
Thank you, sir, for the wonderful session. You gave insight on the patentability criteria, prior art searching, steps involved in it, and so on. Thank you so much. Now we'll move to question answer session, sir. There are many questions from the participants. I'll read out few. First question is Rashmi from Rashmi H. In software, is algorithm is patentable?
The algorithm is patentable when it's applied to some controlling mechanism. If it's applied to some machine, it can be patentable. If
Okay,
not,
sir.
a mere algorithm cannot be patentable. It protects under copyrights.
Okay, sir. From Prithviraj, if the product is combination of many other patented items, can it be patented again?
Come again, madam.
If the product is combination of many other patented items, can it be patented again?
Yes, it can be done. For example, A and B combined, provided it provides the unique solution, then it can be patentable.
Okay, sir.
The thing is that it should give a unique solution.
Okay, sir.
Yeah.
From another participant, Syed Khan, how to trust the patent office agencies if the secrets are sold to the others without any knowledge of the original inventor?
It's very tricky question. Like, Google search is similar to
We
Google.
have to test actually.
Google search. I don't know whether somebody can. For example, there is a one lab which is very active in research, and they have developed. Then, if they do some Google search, others can track that. That's possible. Okay. So patent office, I don't know. It's a trust. Beyond that, I can't answer that.
Yes, sir. I'll take up one more question from Sangeeta SM. Even after searching the synonyms, sometimes X person might have used the other languages such as Spanish, etc. Can it be considered as prior art?
Yes, that's why I told you we need to do the only the keyword search. We need to do the classification search, assignee search, and inventor search. Then only your search is complete. Even if you spend a lot of time, I tell you, any search won't be a complete search. That's not possible because this database is such a huge in size. So we cannot do the complete search, but to be confident, we can do search by using keyword classification and other things I have mentioned.
Okay, sir. Thank you so much. I'll take up the last question.
Yes.
The copyright infragmentation is taking place, especially author works and musical performance. How much
Yes.
percentage is permitted, and what is the maximum duration these products can enjoy the original owner? Exclusive rights.
Yeah, for copyright, as far as I know, it's a 60 years. Okay, and then how much percentage? I'm not sure about that. How much a percentage overlapping is allowed? I'm not sure about that.
Okay, sir. There are so many questions, sir, but we'll, as we're running out of time, we'll wind up the session. Thank you all the participants for the active participation. Thank you once again. And the next session will start at 11:30 a.m. Thank you, sir. One and all.